Thank you very much, Noreen and Madeline, for covering the issues so well. I reasonably expect that I will not have to by the end of this presentation, because I think that most of the benefit of then you find that to go home, so there aren't too many questions to ask. So I'll just dig right in without wasting a lot of time. My task here is to discuss how to navigate the challenges in remote hearings or virtual hearings, as and I would use those terms interchangeably. Between Tunde and Madeline, they've done the fantastic job of explaining what ODR is, and also taken time to highlight that, you know, different aspects of dispute resolution do happen online. So even if you don't tag it as ODR, you would do a lot online. So my focus would be the hearing aspect of the proceedings. So after you've decided to go with ADR, and you've also decided that your dispute should be resolved online for whatever reasons, how then do you go about ensuring that your resolution is one that is suited to your dispute, and more importantly, one that is enforceable? After you've taken whatever the resolution is or the decision is at the end of the ODR process, how does that remedy help you to move forward? Obviously, if all the things, if everything that you require to take a valid decision from the process is not in place, then you run the risk of going through the entire process for nothing, because then you may not be able to recover or take the benefit of whatever the outcome of the decision is. So this is just to help sort of bridge the gap, so parties have, so participants have a clear understanding of sort of what to do. I know it's, you know, we still have a lot of gray areas around regulation, but that's not to say that we cannot take advantage of ODR presently. So my outline is very simple. I'll talk about the legal considerations, then the technical considerations, and finally the practical considerations. And I'll jump right in. For the legal considerations, obviously, you will start with the agreement of parties to resort to whatever form of alternative dispute resolution is suited to their dispute. And I start by referring to the arbitration or submission agreement, because that's the document where parties agree how their dispute will be resolved. I should stop to say here that ADR is usually a party-driven process. So you will see that a lot of what we'll discuss going forward will have to do with what parties decide or what parties agree. So the document or the basis for the ADR mechanism that you select for the resolution of your dispute, you know, the foundation for that process is your arbitration or submission agreement, or maybe this is narrowly construed, I would say your dispute resolution clause. So in whatever contract it is, you have that that's regulated.
Sorry to interrupt. Someone just wants you to enlarge your screen so that it's visible. Brilliant.
Okay, is it better now?
It is, thank you.
Okay, as you were speaking, the same thought crossed my mind. So, right. So the underlying dispute resolution clause or dispute resolution agreement would determine, you know, what sort of disputes the parties, what sort of mechanism the parties would use to resolve their disputes. And that's the foundation for resolving any dispute. Now, with respect to ODR, because online hearings or virtual hearings are fairly recent phenomena in this space, you will find that parties may already have a dispute resolution clause that pushes them in the direction of ADR, but nothing specific in the clause that says you can use, you can do a virtual hearing or an online hearing as opposed to a physical hearing. And sometimes that might be a bit of a challenge. So I've listed consent as the second thing, because parties then need to agree that they want for their disputes, for the hearing aspect of the process to be carried out online. So once they've had that agreement, then it makes it a little bit easier for you to then proceed to ODR without any issues. Now you'll notice that I've cited the sections or the provisions of a particular protocol. So it's at the bottom of the list, and every time I refer to any protocol in this presentation, I'll be referring to the African Arbitration Academy Protocol on Virtual Hearings. Not necessarily because it's the best one out there, but because it's the one that's deliberately designed for Africa, and I thought maybe that's a good place to sort of draw all my references from. And then the final thing I would say about legal considerations is the governing law, and Madeline did a good job of touching on, some of the issues around the local law. Now, for those that are not lawyers here, I'm trying to avoid any kind of legal speak. When you refer to the governing law, usually in your dispute resolution clause, parties would have agreed what laws will govern the dispute. So in terms of your considerations for ODR, that would be the go-to law to look at to see whether it is within the purview or whether the law allows you to resolve your dispute online or not. Now, I will not go into the debate around what happens when the parties don't state a governing law, or the conflict of law issues around the different laws that may regulate your dispute. But on the face of it, sometimes you have a governing law in your dispute resolution clause. That's the first place to look when you're looking at whether or not the law allows you to go to ODR. So for someone who asked a question earlier around if the parties are from different jurisdictions, one way to reconcile that issue is if your agreement has a governing law, then you automatically know which law applies to the procedure. But then there's also what is known as the law of the seat. So parties may decide that we want our arbitration to be seated in this country. What that implies for your dispute is that the law of that country will have some impact on the procedures that you would adopt in resolving your disputes. In Latin, it's called the lex arbitri. You will find that lawyers used to speak a lot of Latin. Thankfully, we speak more English nowadays. But so the law of the seat, also known as the lex arbitri, could impact on what to do in terms of a virtual or an online hearing. And you will see that the final law that I've cited there is the UNCITRAL model law. It's a model law, but it's an important one because most African countries, most countries around the world actually model their arbitration laws around the UNCITRAL model law. So you will find that depending on what jurisdiction you come from, there's a likelihood that the model law also provides basic guidelines on what to do in procedure. And I've highlighted one article because that article tells you how an award, which is a decision in an arbitration, if you're going with arbitration, may be set aside if procedure does not comply with one agreement of parties. Remember that we said ADR is a party-driven process. So the kind of procedure you use for resolving your disputes is something the parties need to agree. ODR is one of the things or one of the ways parties need to agree what kind of procedure will be used for their dispute. So agreement of parties is important, and for most laws around the continent, I think that you may find that the primary legislation regulating ADR in your jurisdiction would have this kind of provision, suggesting to you that if you want ODR to apply, then you will consider first what the parties agree, what you put in your arbitration agreement. And then, of course, in the absence of the agreement of parties, then you will then look at the provisions of that law. So what happens is most of the laws would provide a default procedure that parties can implement should their arbitration agreement not have specific provisions for certain aspects of the dispute. So basically speaking, in terms of the legal considerations and how to navigate this, it is often important for parties to take a careful look at their arbitration agreement. For most jurisdictions, if your arbitration agreement provides the specifics for what you want your dispute resolution process to look like, then it's easy for you within that agreement to go to use ODR as an option to physical dispute resolution, because that's the underlying instrument that gives your process the legitimacy that it requires. And then you'll find that everything else is filled out by the law depending on what parties have omitted to include in their arbitration or their dispute resolution clause. Subsequently, we will talk about the other things that you can look at to just ensure that you navigate the legal issues. But in summary, once your arbitration agreement has the basics, there are other avenues that you can use to fill in the blanks. I say this to clarify that you do not necessarily have to have everything in your dispute resolution clause, so that we're not bogged down with thinking, oh, maybe my dispute resolution clause now has to explicitly say everything that would happen. Sometimes it's not possible to envisage. So it helps to just have the broad headlines of what you want the dispute to look like. And then along the line, there are other things that can be adopted that would help clarify the process. But in terms of legal considerations, I would say these are the sorts of things to look out for. And then the next issues we'll look at are the technical considerations. Again, I'm happy that Madeline took time to talk about some of these, so I will not dwell on them. Obviously, you need computers, phones, or tablets. You need cameras or microphones. Pretty much what's happening in this webinar bears some resemblance to what would be happening in your virtual or remote hearing. So if you've chosen ODR, when you get to the hearing aspects of your proceedings, whether it's an arbitration or a mediation, you will find yourself in a setting like this. Obviously, you would need your computer or your phone to log on. You will need a camera and a microphone, just the way you can see and hear us. That's what your virtual hearing room would somewhat look like, with a few adjustments, because that's a bit of a more serious, more formal setting, and the requirements are slightly different. And then you would, of course, need audio and video recorders, because this is a dispute resolution process, and there will be evidence tendered, and you need all of that information to help either the third-party neutral reach a decision or the parties to reach a resolution, depending on what mechanism you're using. Then the audio and video recorders are important. And then for the software considerations, so the things, and I use the word software here very loosely, but I'm talking about the things that are not the physical equipment that you may see. So there's internet connection, and I've added backup there. I think Madeline also mentioned that. Because we know that our internet has a tendency to be unreliable, the recommendation is always to have a backup internet provider, so that should anything happen to your communications while the proceedings are going on, then you can fall to your backup internet provider to help you carry on proceedings. I would like to add here that it also helps to consider power and backup power. I know Tunde brought out our hand in public when he mentioned Lagos and power outages, but these are very real considerations. These are very real considerations. So definitely power and backup power would be good. And then there's platforms as well. Again, Madeline touched on platforms. And now I feel bad because I didn't add iResolve to the list, but I've given some examples here. There's Teams, there's Zoom, there's BlueJeans. Teams is owned by Microsoft. Zoom is where we are now. BlueJeans is a little less popular, but it's also one of the platforms. And there's quite a number of them out there. And you could take any number of factors into consideration when picking out your platform, but the key considerations we have discussed here already are things like privacy and cybersecurity. So like Tunde mentioned, maybe you don't want to go to the open source platforms because you don't know how secure those are. And then I've added here, one of your software considerations should be a virtual data room. Because you're doing everything online and your hearing is also going to be online, it helps to have a document repository, preferably one that is properly indexed and the documents are properly arranged, and both the third-party neutral and the parties have had opportunity to interact with the documents and understand, how to navigate those. That helps you when you come to your virtual hearing room, because it makes it easy when proceedings are going on for everyone to be able to follow the conversation. Finally, I've added transcription software because oftentimes at the end of these hearings, you would require transcripts, and depending on the sophistication of your platform, sometimes you have software that readily transcribes everything you discuss. As you discuss it, it transcribes it so that everyone can refer to record of proceedings so that you can reach the end determination for the dispute. But if that's not available, then you can get transcribers. So your audio and video recorders will then come in handy. Once you've recorded, transcribers can take the recorded sessions and transcribe them so that everyone will have copies of proceedings, and that would help you understand how decisions in your dispute have been reached. And we're going now to the practical considerations. So there's some items here that we'll discuss in a little bit more detail when we get there. So I'm just going to skip. Okay, before we go to that, this is just a picture of what your setup could look like. Oftentimes people have less than these. I'm sitting here, I have my laptop, a large screen, and my phone. So I have 3 items out of the 5 that are here. And my microphone is inbuilt, so is my camera. So you see that I don't have an external webcam or the external microphone. My point is, it helps to have an idea what sort of setup you need to have for your virtual hearing so that everything moves seamlessly without any issues, especially because apart from the audio and the video, there's every likelihood that you will be going through volumes of documents. And Tunde alluded to the fact that some cases are so large, you shouldn't be looking at ODR for them. I agree. But even for the cases that, have a reasonably manageable number of documents, it helps to have an additional screen so that navigating between documents, and if you're a witness or if you're counsel providing testimony or whatever, you are able to manage the transition seamlessly. And of course, for those that are practitioners here, if you're the third-party neutral, obviously you need all those to be able to also follow the conversations, because as witnesses give their testimony, they will be referring you to their statements or to the exhibits or documents that they're providing, that they're relying on to provide evidence. And having this kind of setup helps to keep the proceedings seamless. And because it's virtual and everybody is in different locations, the benefit of your cell phone is just to be able to interact within the team. And we will discuss witness testimony at some point, but your cell phone is really for interactions within the team. It's not for counsel to guide their witnesses. So these are little things that we need to bear in mind. So finally, for the practical considerations, I haven't provided a lot of detail here, but what I've done is to provide references to the different articles in the Africa Arbitration Protocol that you can refer to. And I've provided one reference to the ICC checklist because I think it's a little bit more robust, and that's another document, very good document that you can refer to. The ICC checklist came out in 2021. The Africa Arbitration Protocol came out in 2020. I think Madeleine made reference to the checklist. But in terms of practical considerations, so the first thing would be location and setup. It will be good for everyone who is going to be at the hearing to be at a quiet location, minimal interruptions, stable power, stable internet, and to have the sort of setup that we've just seen. Now, one of the things that you may consider, depending on the ability of parties to access technology, and I think someone asked that question after the earlier presentation about the question of technology gap between the parties. one of the recommendations you will find in the Africa Arbitration Protocol is if you don't have the requisite technology, it's good to look for an institution that has the facilities, that you can then use. So as opposed to that party trying to sort out everybody, you may all meet at one location that has the requisite facilities so that you'll be able to join your proceedings without much difficulty. Technical specifications, I will not go into details of that, but essentially, if you look at the Article 5 of the protocol, you will see that the basic specifications that have been provided to give parties and to give third-party neutrals an idea of what you require to be able to set up properly and run a virtual hearing without any interruptions. And it doesn't go much beyond what we've seen in the previous slide. I just want to add that looking at those text specifications, you may find that some of the information will be flying over your head. I know for me, certainly, when we got to that part of the protocol, the information was flying over my head. But the point of those specifications is so that you can get technical support to help you with the setup and to ensure that proceedings run properly. And then you have other things like hosts or controls. Obviously, somebody should control the hearing room, ensure that only people who are authorized to come in can come in. You would need a host, somebody to host the meeting. So depending on what platform you're using, your meeting will be hosted somewhere. Hopefully it's a reliable host. And then I particularly like item 6 communication protocol, because that talks to what happens, who speaks, at what point. Do you turn off your cameras? Do you mute your microphones? In what order does the tribunal call you? And things like that. But those are all the considerations that go into the virtual hearing. And this is just to give everyone an idea of what really happens. So my job here is really to paint as much a picture as possible of everything that you've heard before now. And again, I will try not to bog you down with the technical details or to speak any legalese, because this is really just an awareness session, and I understand that we have a mixed audience. So other things you consider are the hearing times and the schedule. That's very important. If your dispute is across different countries, you will be in different time zones. So a hearing schedule should consider what time, what time all the parties or the persons attending the hearing, what their different time zones are, and what's the best time that everybody can log in. Sometimes, depending on how far apart you are and what the different time zones are, you may not find a timing that is convenient for everybody. So if your hearing is more than one day, you may switch it around. If some people are up during the day and others at night, on the first day, you might switch it around so that you create some kind of fairness and equality. And then if there is a language barrier, you would need interpreters. As part of your technical requirements, if you're having interpretations, then you will need multiple audio channels so that one person is speaking in English, and if they're translating into or interpreting into other languages, other people can hear the interpretations in the other languages through other channels. I've talked about transcription. I think guidelines, rules, and protocols are pretty much self-explanatory, because everything I've said now has been out of 2 key documents that provide some kind of guide as to what to expect and what to do if you have to resolve your dispute online. I would want to add at this point that even though I've referred to all these protocols, none of them is a mandatory document. All of them are really just should I say, as the word implies, guidelines that parties can then adopt. Remember that we said parties, ADR is party driven. So they're guidelines which parties can then adopt. When you adopt them, then they become applicable to your dispute, and they now form the basis on which your proceeding is conducted online. So pretty much this is the end of my presentation. I will do one thing though. I want to quickly show you, while the earlier presentations were happening, someone asked a question about what kind of document to refer to if you want your dispute to be resolved online. And I thought to find you a template and share something that you might find useful. So you will see that in Annex 3 of the Africa Arbitration Protocol, the protocol tried to provide a model clause or agreement that you can use for virtual hearings. And it simply says the undersigned parties agree to proceed with a virtual hearing regarding the claims. I'm sorry, the document is not very, okay. Yeah, regarding the claims and arguments and everything concerning their dispute. But what I like particularly about this is the second part of the alternative clause. It says the hearing shall be conducted virtually. The last line, it says, we further agree that no objection shall be taken to the decision, order, or award of the arbitral tribunal on the ground that the hearing regarding the dispute was conducted virtually. This is just to answer the question of navigating the legal issues. Because ADR is party-driven, once parties have given their consent to a virtual process and have indicated in their agreement that they will not object to the outcomes, then you find that you don't have a lot of issues around challenging the legality of the award or the decision that is the outcome of your process. So I will stop here, and if there are any questions, I'll be happy to answer them now. Thank you.
All right, thank you. Thank you, Laura, for your insightful presentation as well. You took us through the legal, technical, and practical consideration when it comes to ODR processes. And we have a couple of questions on the chat box. I'll start with one, and thank you, Tunde. Tunde has answered some of the questions that were in the Q&A box, but there's someone who's asking about data privacy rules across borders during ODR proceedings, for instance, in African streets. So the question is, how do you ensure and observe data privacy rules during ODR proceedings?
Sorry, say that again.
The question is around data privacy laws and rules when it comes to ODR proceedings. And so they're asking, how do you ensure and observe data privacy when it comes to ODR proceedings?
Right. Well, it's a very interesting question. And in terms of data privacy for ODR proceedings, I think that typically what you would look at, again, would be the sort of rules that apply to your dispute or the seat of arbitration. But I want to clarify very quickly that for a lot of African jurisdictions, when you talk about, actually for most jurisdictions generally, when you talk about data privacy, this refers to personal data that you collect from individuals for the purpose of whatever it is you collect it for, and ensuring that you do not use that data for anything outside of what you've agreed to use that data for. So when you come to your ODR proceedings, I think that data privacy in that context will not be, for me, a major concern. The entity in the whole setup that would have data privacy, should have data privacy, should comply with the data privacy requirements would be, for instance, the host, the platform that you're using for your ODR proceedings, because that's the entity that you would all sort of supply your data to for the purpose of logging onto the platform to use that platform for your proceedings. But in terms of, for instance, the third party neutral that will be determining the case, or the parties that will be coming together to resolve a dispute, data privacy concerns in that regard may not, should I say, your use of the data in the proceedings may not fall into that category such that, violation of data rights of all the participants will become a major issue. So that's my that's the context in which data privacy is largely legislated around the continent. And so that would be my approach to applying it to an ODR scenario.
I think if I would add to what Laura has said, and she's dealt with the matter quite adequately. The only other circumstance I would see that becoming a problem is when you are submitting documents. And what you're concerned about here is when you are actually submitting documents and you're worried that your platform is being used to submit documents. If you are in control of those documents and they have been submitted to you and they're private documents, then you need to be concerned. So the better way to do that is to use a neutral platform and then shift the burden and the risk to someone else's platform, rather than making yourself or your firm be responsible for that document. That's how I would deal with the multi-jurisdictional aspect of that. But again, depending on which kind of ADR you're doing, for example, if it's arbitration, mediation, or negotiation, even the platform and the access to the document in the first place will have, the answer will change depending on which mechanism you're using to resolve the dispute.
Yeah.
If I can add on to that conversation, from a practical angle, as a mediator, how to manage or minimize the risk of the privacies being breached. For example, as a mediator, the kind of skill that I've found to work very well is at the stage of opening the session, your opening statement should be very clear and remind the parties of their obligation to maintain the documents that may be exchanged, either maybe through a neutral platform that they've both agreed to, or even amongst themselves by way of email, that needs to be well observed. The principle of confidentiality and privacy should be observed. Then we also use, as mediators trained maybe for some of us under the CAP, there's the guidance that was issued just at the wake of the pandemic. And that has a checklist. And one of those checklists provides for the neutral to ensure that there are no attendees, no other attendees may be present at the site of that person in a mediation without having been disclosed. There's actually a requirement of there being a participant list sent prior to the hearing or prior to the mediation session, where you've agreed these are the non-attendees, but we agree them to watch in brief, for example. Then if we shift now towards arbitration from a practical element, we've seen the works of the international, if I get the acronym right, I'm really bad with acronyms, the ICCA, the Commercial Arbitration Center. They worked on a very robust piece of looking into a protocol on cybersecurity. Yeah, so these are the kind of documentations that lawyers and also SMEs, especially those conducting businesses in online environments, to be familiar with. Then the certain protocols also delve into ensuring that the arbitrator, at the very onset of an arbitration hearing, that no recordings are taking place. And usually there's that issue of consenting to a recording prior and so on and so forth. So there are certain skills or techniques now also on the practical side of things that we need to consider in terms of trying to minimize that risk of breach of confidentiality, breach of cybersecurity, and the rest. Thank you.
Thanks, Madeleine and Tunde, for chipping in. Laura, there's a question about other considerations. You've talked about legal and practical considerations in your interventions, and someone is asking, as an SME owner, before you agree to an ODR process, what key items should you consider?
Okay, I think that's an excellent question, and I think that Tunde touched on some of those at the beginning of his presentation. If I run an SME and I'm looking at dispute resolution mechanisms, some of the things I would consider would be the nature of the dispute, the industry, the size of the dispute or the complexity of the dispute, the value of the dispute. So, you know, the kinds of things that would impact my ability to use that dispute resolution mechanism efficiently. And if I were to borrow Tunde's example of the wedding party, if your wedding costs you $20,000 and you picked, for instance, ADR as a dispute resolution, and you picked arbitration as a dispute resolution mechanism, you know that you're going to pay arbitrators fees, you would pay for administering the arbitration, you would pay counsel fees. Those sums in comparison to your wedding party, it may not be worthwhile to pick, or, you know, that sort of dispute resolution mechanism, unless you maybe went for the option that is specifically designed for SMEs, for instance, that has a fee cap, then that would be viable for you as an SME. And then, of course, you know, common mistakes. In Nigeria, for instance, our Arbitration Act has a default provision for 3 arbitrators in the event of a dispute. So if, for instance, your dispute resolution clause is silent on how many arbitrators, you're automatically stuck with 3. So as an SME owner, if I were to consider, you know, if I were to look at what to consider before picking a particular dispute resolution mechanism, I would find ways to look at what mechanism works best for me. If I'm using an institution, what institution has provisions for SMEs, and in those provisions, do they consider the nature of my dispute, the value of the dispute, you know, the industry, do they have specialists in that area? You know, how would this help me to keep my business costs within reason, while ensuring that in the event of a dispute, I get speedy resolution? Sometimes you can reach these decisions by asking a few questions. Sometimes you have to engage extensively and maybe seek legal counsel. I would always recommend to SMEs, I know that you know, it's important to keep your costs low, but once you start entering into, you know, complex legal transactions that require a little bit of documentation, you know, apart from your everyday, like, should I say, oral contracts that don't require much, then you want to seek a little extra advice so that you save yourself the hassle of, you know, expending so much to resolve a simple dispute.
Thanks, Laura. Sorry, was there any other intervention? Okay. There's a question about institutional and ad hoc ODR, so to speak. So we've talked about ODR providers and how that goes, but are there instances where a dispute arises or disputes can arise, and, you know, SME owners can now decide after the fact that they would want to employ ODR processes, and, you know, how does that go and what do they need to consider?
Oh, absolutely. I mean, because ADR is party driven, parties can decide, you know, after the dispute has arisen, that this approach doesn't work for us and we would rather do something else. And I've been in one particular dispute where parties moved from a full-on arbitration hearing to a documents only arbitration with no hearings, because they looked at the cost of the total financial outlay for the arbitration and decided it was not worth their while. They were going to pay the arbitrator, and then they were going to have to pay everyone's costs to meet in the same city so that they would hold the hearing. And they looked at their disputes, they looked at the contracts, and counsel had a conversation with each other, and they wrote the tribunal to say, look, we would like this to be a documents-only arbitration, and we don't want any hearings. And that actually happened, and I think that was in the best possible way that it could have been resolved. And really, looking at the documents before the tribunal, to call oral evidence. So yes, it's possible for parties, you know, once you've gotten into the process and you realize this doesn't work for me, to turn around and say, why don't we make adjustments in this direction or that direction so that you find a solution that's better suited to your dispute.
If I was to add something to that, the specific aspect of that question was whether also you went ad hoc or institutional. And if I put my academic hat on, I would say ad hoc. But if I put my practitioner's hat on, I would say what you lose in going in the flexibility of ad hoc is gained in institutional arbitration or mediation or even expert determination in the terms of the rules of those institutions. Now, what Laura has said is extremely valid in the sense that you can withdraw even when you're in a particular system, but the problem is to use the right system in the first place and to find institutions and particular rules of those institutions where the costs are capped. Yeah, look at the value of what you're going to be fighting over. Look at the rules. How basic is it? Even the scant rules is better than no rules. The example of what I'll give you is the business administration scheme of the Chartered Institute of Arbitrators, for example, where they have, you know, you get an award for $2,000. And for most business owners, if all in, you're going to pay the institution and the arbitrator, and it's documents only, $2,500. It's still a lot to most Africans, but at least you will get an award for it. That's probably an alarm telling us we're run out of time, hasn't it? Then you will see that that is a preferable option because you have rules which fill in the gap, and people don't understand that ADR it's a very flexible thing, but it's like swimming in the ocean. If you do not have a lifeboat in terms of rules to guide you, you can get lost very quickly. So do your research. Don't try and sign a contract without showing it to your lawyers first, because I think that's the first pitfall we have to say to small lawyers. I'll quickly do this contract. Don't worry. I'll just sign it. Oga, just sign. Just sign. Just sign. Don't worry. Don't worry. We don't need to show the lawyer. Yeah. The small fees that your lawyers will charge you to look over it will save you a lot of pain later, and they will be able to guide you, saying, okay, fine, this is what this dispute is about. This is the value of it. Why don't you use this particular dispute resolution mechanism, yeah, that will give you a stripped down version, fix your costs, and then you have an award at the end of it at minimal cost to yourself, even if the other side doesn't pay. That's an important thing. If you think about the BAS rules, it's 2,500, but that's split between two parties. Even if the other parties doesn't pay, it's 2,500 to you, and you still get an award at the end of it. Those are the kind of practical things that your lawyer will be able to do for you at a knockdown price, as opposed to fixing the problem later when you've copied and pasted the wrong clause from the internet. Yeah. Laura is laughing and Madeline is laughing, but that's it. We fix. And I'm spoiling business here. I am, but I'm spoiling business. I say, go and make the mistake and we'll come and fix it later Sunday. No. I am spoiling business. Yeah, but
fine. I mean, waiting for the businesses to survive. So.
But exactly, it's important for your businesses to survive. Yeah, because we hope that you grow, and as you grow, we also make more money, because then we hope that one day we don't have to insert clauses that are capped into your contract, that we can insert the big boy clauses into your businesses and make even more money when the things go wrong. Yeah, we have to be honest about that as well. So the small bits that you pay us now will save you a lot of pain quite later.
Yeah. Just to add on to the question there, and Tunde has addressed this, and Laura as well, but I wanted to look at it from a different angle, in making sure that we understand that the ODR provider is not coming in to take over the institutional role.
Yeah.
As an ADR provider, institutional role will still remain as important as they have always been in ensuring that the case is administered in accordance to the rules of that type of trade or of that institution, and as the way the parties have agreed to do so. As Tunde has highlighted, the flexibility in terms of formulating these rules is really up to the parties. So the provider comes in to add in the technological element only, the fourth element to that process. And so the provider is opted into at the stage where the arbitration is already being, has already been instituted, maybe by the Tanzania Institute of Arbitrators, for example, and they've gotten to a stage where, oh my, we cannot have a physical meeting. Let's think of having a virtual one. They can opt in, as Laura presented. The consent of the parties will be obtained, and they can opt in for that virtual hearing if need be there, and have that virtual hearing being administered, or at least assisted by this ODR provider, or this portal that is being provided by ODR. Institutions, as I said in my presentation, have come about with online rules, online arbitration rules. Great examples that had already existed, I can think of, is the Russian Arbitration Association, the CATAC online arbitration rules, and there are several more newer sets that have come about that are introducing the element of technology. And I think with that note, the UNICITRO expedited arbitration rules of 2021 are interesting because they also provide for the option of using technology to resolve the dispute so as to expedite the process.
Thank you. Thank you for the clarification, Madeline. And the final question, I see we have taken quite a bit of time. It's about recommendations, Laura. People are asking, what would you recommend for recording? What would you recommend for the transcription software that parties can use for the ODR process?
Honestly, no transcription software comes to mind right now.
Just record. Just press record. Just press record. Just press record. Why do you need transcription software? Just press record.
Let me tackle this one, please. Let me tackle this one here.
I'm coming, Madeline. Just give me a moment. Pretty much all the platforms have a recording option. And I found that for Africa, our accents are very unique. Before I came into practice, one of the things I did was tech for courtrooms, and we tried to install recording devices in our courtrooms. And the problem we had was the software just could not manage our accents. As soon as you begin to recognize the Yoruba accent, an Igbo person comes in and everything is thrown out. As soon as it looks like you've understood the Nigerian accent, a Ghanaian comes in and, And then you're looking at this transcript and wondering, is it the same proceedings, or what did they mean to say here? So I'm sorry, I don't know any transcription software that I can recommend, but you will find that it's always easy to find people to transcribe. Some institutions would offer you a range of transcribers to pick from, and those people, because they're actual human beings that will split up the work and transcribe it for you, you will find in terms of accuracy, it's a lot more. I mean, you will still have to go through it word for word and maybe sometimes compare it with your recording. But this is at the back end. I mean, for parties, it's not an issue you may have to deal with, but if you are the third party neutral, then you would still find that there are some gaps. And whoever's doing, if you have someone who has responsibility for sort of proofing that for you, they need to compare it carefully. And you will still need to hear the recordings beside the transcription to be sure they're accurate. So my recommendation for now would be use transcribers as opposed to transcription software for now. We'll get there, but we're not there yet. I'm sorry, Madeline, you can go ahead.
No, that's we've it was a joke, and I think it was well captured by your response. This is the challenge that we face, being that we, for example, currently I offer a service under my firm. It's an alternative service that was really to ensure that I have a niche in the market in attracting the volumes that Tunde is speaking about. And so the transcription service is a difficult one to manage because of that language issue. So even if we do end up getting a software, and there are several in the market to do the automation work, we end up, I have a paralegal that does the transcription manually because of the language barriers. But if it's a matter that we find that it's, the English accents are well captured, then we can use that automated software. But also that gives us a little bit of a jargon there that needs to be always reviewed prior to sharing with the clients. So it's a very tough job. But what I've seen, as I said earlier, is that there are people who are well equipped to do this work. I cannot recall a name, but usually, yes, the institutions would offer you a list and you would be able to elect.